Well, thank you, everybody. As I listened to this morning's presentation, I'm amazed our paths have not crossed before, because all the presentations deal with the stuff that I deal with every day from the law and policy area. And when it was described, I know the function of agrologists in the field in agriculture, but when John Kennelly described part of your function as cleaning up after the engineers, I thought for sure we're in the same field. In fact, the whole of our society is probably in that field. So what I'd like to deal with is, why is water law important? Well, Bill Shottick this morning mentioned that water issues in Alberta were at the center of a perfect storm. I'm not quite as gloomy as that, but I think what's interesting about Alberta is we have all the world's major water issues, most of them rather, here in the microcosm. Water and energy, water and food, water and the natural environment, to name but three. Bob Stanford described the challenges which we will meet in allocating an increasingly scarce resource in the future. That's what water law is about. So what I'd like to do is to first of all describe our present system for you briefly, and then to talk about some of the shortcomings and how those shortcomings might be addressed. So in order to do this, as is typical with law, we've got to go back a long way. We've got to go to the birth of Canadian water law, which was actually roughly the same time as European settlement arrived in Western Canada. Because when European settlers arrived here, particularly this far west, we've got to remember that they'd been lured by promises of a land flowing with milk and honey. But what they found was Palliser's Triangle. And it was obviously they were all encouraged to arrive here to pursue agriculture, and it became quite clear that agriculture in most years without irrigation was impossible. So this created an enormous swell of discontent amongst the newly arrived immigrants, because the problem with our prevailing water law, that of riparian rights, was that large-scale, any-scale irrigation was almost impossible. Why? Because the riparian rights doctrine said that only people who owned riparian land adjoining a watercourse had any right to use the water. And even they, remember someone said, I think Bob Sanford said you've got to be careful about lessons from the other parts of the world. The riparian rights doctrine grew up in England, where water shouldn't be short because enough of it falls there. But even then, riparians and that system could only use an amount of water which didn't result in a perceptible diminution in stream flow. So you could use water, but you couldn't use the water so it made a significant difference to the stream. So basically, you couldn't carry on agriculture. So in a very early stage in Alberta's history, Charles Card arrived from Utah with the Mormon settlers in Cardston. They'd irrigated in Utah. They started to irrigate around Cardston, and somebody came up and said, "You can't do that. It's against the law." So basically, a lobbying group grew up in Western Canada with a sympathetic William Pierce on the Federal Department of the Interior, and as early as 1894, the federal government passed what is still our basic water law, the Northwest Irrigation Act of 1894. As its name implies, it had the sole purpose of assuring adequate, secure supplies of water to irrigation projects. It began by saying, okay, here we have all this water in Western Canada. This is the Northwest Territories from Manitoba, Saskatchewan, and Alberta. The first thing the federal crown did was say, we've got to get control of this resource, so we'll declare that the crown owns all the water. And the phrase they used by 1895 is, the property in and the right to use all water is vested in the crown. And of course, we then move to a typically Canadian solution. The crown's attitude is, that's our water, you can't touch it unless you have a license from us. So that's how they established control. With the exception, of course, of riparian owners who were allowed to use enough water for their domestic purposes without a license. But any large-scale use of water, you could not then, after 1894, use that water unless you first obtained a license from the federal government. And, well, they didn't begin licensing right away because sort of Murphy's Law, they passed the act in 1894 after a long drought, and then there were 6 or 7 really wet years, so nobody really needed a license. But by the early 1902, 1903, lots of licenses are being issued, and these licenses are really interesting. They're granted without a term limit. So the license says you shall have the right to divert a certain amount of water, period. It doesn't say until for 10 years or 20 years or anything else. And of course, although they don't have a time limit attached, because they don't have a time limit attached, the holders say, well, they're perpetual. They can never be cancelled because that's not quite correct, but nevertheless, that's how they're viewed by those that hold the licenses today. So they're granted without term and viewed by their holders as perpetual. And in the early licenses were granted for very large quantities of water. It was the old CP lands, which were then transferred to irrigation districts. So my friends at the Eastern Irrigation District have a license to divert 762,000 acre-feet of water per year. That is an enormous quantity of water. It's enough water to cover 762,000 acres to the depth of 1 foot. Right? That's a water right to kill for, not to die for. And then you got the right to that amount of water even if you didn't use it all, even if you could never use it all, because what we'll see is that although it's not a property right, it's a secure right because of the fact that you had to be really bad in order to lose your water license. You actually had to break a rule of the Act. There were a few rules in the Act. If you never used water at all, you lost your license. But if you underused the water, you didn't lose it at all. So you had to be really bad before you could lose a water license. It was very secure. Granted without term, very hard to lose. And then a feature of the Act which has attracted a lot of attention recently, you get your license, you can only use water for the water for the purposes set out in your license. So the old irrigation district licenses say for irrigation and other agricultural purposes. You can't use it for a power plant, you can only use it for those purposes. But the most important thing was this system had to figure out what to do in the event that water became short. So it applies the principle now known as FITFR, which says this: you have priority to the water according to the date of your license. If there's not sufficient water to supply all licensees, the senior licensee gets every drop to which the license entitles that person before the next licensee gets any. Right? So that's called first in time, first in right, FITFR by many people now. That's not exactly accurate because you didn't get as much as you wanted. You got only the amount the government allocated to you, and they had a rough idea of how much water you should get for how much land. But nevertheless, that's the underlying principle of resolving water shortages. Senior licensees get water before junior licensees. There's been a lot of fuss made about this recently. A lot of people, I saw an Alberta agrologist paper a few years ago, someone attacking the system. Some people in the agriculture faculty don't like it. I don't think it much matters, because up to 1975, we hardly ever saw FITFR in action. That is, there was nearly always enough water almost every year to satisfy all users. And being Canadians, if there wasn't enough water to go around, they tended to talk it out and make little cooperative arrangements. Well, I will take some water this week so you can have your allotment next week. So it didn't actually work entirely like a priority system does in the United States. And even today, only in the Great Drought of 2001 did we really see FITFR applying in a significant way where some significant water users were cut off because they were junior and there wasn't enough water for everybody. The other factor is that the water licenses were tied to the land in respect to which they were issued. So you received a water license, if you're an individual farmer, in respect of your quarter section of land. The legal descriptions attached to the license. And the Acts used to say that the water license is tied to land and inseparable therefrom. So you couldn't deal with the only way you could transfer your water license was to transfer your land. Because the license was inseparable from the land, it went to the buyer in that situation. Just for the sake of completeness, bizarrely by 1897, British Columbia had adopted a very similar system of water law to this one, so that really by the 1900, Canada from Lake of the Woods to the Pacific Ocean was governed by an almost identical system of water law. Well, this all worked very well for about 25 years. But then somebody scratched their head and said, hang on, if we keep giving water out by way of licenses, one day we're going to run out. And this happened in the boom years following the First World War. Cities like Lethbridge and Medicine Hat were starting to expand, so the government said, what are we going to do if there's not enough water to accommodate the expansion of growing what were then rapidly growing prairie cities? So this created a big debate. What options were open to the government at this time? The reason I want to emphasize this is the exact debate that has been going on in the last few weeks, certainly around parts of the University of Alberta. How do we get water from what somebody perceives to be a less important use to a more important use, the needs of a growing city? So this is what the solution that was adopted in 1931. It's still a law in Manitoba. I'm sorry, there's a lot of legal verbiage here, but if you go to the minister and ask for a water license, and the minister says, there's no more water available, or the only way we would give you water would be to negatively affect the aquatic ecosystem. So we've got no new water to give you. You've applied for a license. Then it says, if the purpose, this is the middle of the statement, if the purpose for which you will use the water is higher than in priority than the purposes of another licensee, the minister may give you a license to the applicant and may cancel or restrict the rights of the other licensee. In other words, it says, the minister can say, your proposed use of water is more important than this person's existing use of water. We're prepared to cancel that existing license and give the water allocation to you. Now, bureaucratic power. So they said, oops, what we'll do then, I'll just do this verbally, is therefore, just to stop bureaucratic power from running wild, we're going to state a hierarchy of water uses. The priority list across the prairies at that time was, it's a league table like this. These are the important uses of water: domestic use, municipal use, industrial use, irrigation and agriculture use, water power, and other use. And the principle was, if you're higher up in the league table than another use, you can get their water right. If you're lower down, you can never acquire a right from a higher use. But the idea is, some water uses are more important than others, and the government should have the power to reallocate water according to the importance of use. And incidentally, the person whose license was cancelled had a provision for compensation for losing their allocation. It never worked. It was doomed to failure. So this still exists in Manitoba, it used to exist in Saskatchewan, Alberta. There is no recorded instance of it having been used. Why? Because the principle on which it's based is hopeless. Suppose that we had infinite wisdom, and in 1921 we were able to say, these are the most important uses of water on the prairies: domestic, municipal, etc., etc. That's true for 1921. Is it true for 2001 or 2012? Is it true in Fort McMurray? The same list of priorities applied in Fort McMurray. Agriculture, high up on the list, industrial, lower down the list. So the idea of trying to say this use of water is always more important than another at all times in all places on the prairies was never going to work. So we still face the problem, despite this created really a safety valve in the legislation, and nobody thought about it until water did begin to look short. And it was Saskatchewan who confronted this in a ham-fisted fashion in 1984. So what they said in 1984 in Saskatchewan was, look, first of all, we transfer the water from the Crown to a Crown corporation called the Saskatchewan Water Corporation then. So you might have held a water right in Saskatchewan then for 90 years. The legislation suddenly said, out of the blue, the corporation may cancel the right of any person granted prior to the coming in force of this act to the use of any water where the corporation considers in the public interest. And if we do, you can't sue us for any reason. In other words, it gave absolute power to the water corporation to say, sorry, your water use isn't very important, we're canceling it and we're giving your water to somebody else. And, I should say to that the philosophy behind this was government, or the Saskatchewan Water Corporation, knows best which is the most beneficial use of water. The holder of the cancelled water right was entitled to compensation, but only for the redundant value of their works, right? The works that were rendered redundant, the depreciated value. Saskatchewan realized it had gone too far. In the 90s, they transferred the power from the Water Corporations Act to the Saskatchewan Watershed Authority, and the Saskatchewan Watershed Authority has to get cabinet approval before it cancels any right, and has a proper measure of compensation attached. The result, it's a lawyer's solution. It's great on paper, it solves the problem on paper, it has never been used. You'd have to be a brave minister to sign on the bottom line and say, you know, your water use, we don't think it's very important, so cancelled, here's some compensation, go away. So when Alberta began looking at this in 1989, it ultimately adopted a different solution to overcome the problem that our system created no room for newcomers and created no incentive for people to use less water. So what we did in the Act, which was passed in 1996, was to say that a person can transfer, I'll use the legal language, the allocation they hold under their license to another person. So in other words, we separated the water license from land. And the legislation says that you can transfer the allocation of water you hold under that license to another person. And the Alberta Environment Fact Sheet says the transfer is voluntary with a willing seller and a willing buyer. It can be anybody else, it can be a gift if you like. So this was the proposal. It was hugely controversial publicly. People shouted the commodification of water, you're doing desperate things to the water system, and the system's not ideal, but what I've done is to put up the Saskatchewan solution and the original federal solution in the Manitoba Act. They're the alternatives. You either try and say some uses of water are more important than others, or you give the government an unfettered right to cancel water rights, or you let the market decide. So we, in the 1996, passed the 1996 Act, allowed the transfer of water allocations. The public outcry was remarkable. I have never given public presentations during we were doing information sessions on the Act where I've met so much hostility about the idea of allowing a transfer of a water allocation. And this almost derailed the entire Act. The government got very cold feet about passing it because it was so controversial. So what they did was to say, very cleverly, okay, we're passing this Act, but there will be no transfers right away. There'll only be a transfer where we have an approved water management plan for a given area of the province. And that means approved by cabinet, right? So don't worry about this, folks. The cabinet has to make a decision before a water transfer will be allowed. And then luckily the drought of 2001 arrived. And they realized that we were facing problems because people were not able to move water around at all. So the South Saskatchewan River Basin Management Plan allowed in 2001 for transfers to occur, but only within the South Saskatchewan River Basin. We had our approved water management plan, and of course the rules were, like selling land, you had to have a valid license before you could make a transfer, and we inserted a large number of public interest safeguards into the transfer process. So we've got to make sure the volume transferred does not exceed the original license volume. There must be no net harm to the environment or to other water users caused by the transfer. The agrologist's dream, if transfer is for irrigation purposes, the land must be suitable for irrigation. And we'll also consider the amount historically used by the licensee. If the licensee has a license for 1,000 acre-feet, but has only ever used 500, then you've got to be very careful about transferring the full 1,000 acre-feet. So we had a lot of safeguards, and in addition, the director had to consider all the factors set out in the South Saskatchewan River Plan, and had to have a public review. It's a public notice, room for objections to the transfer, filing of objections, and only after all of that did the director have the power to approve a transfer. Well, I think the first thing to say is this system's been in place since 2001. We've had a decade of experience. We've had 1 dry year and 9 wet years since then. What have we learned? There have been 52 transfers that have occurred since the system began to operate. That's pretty good. I would say not a single one of them has been controversial in the least from a water management viewpoint. And the first year that happened, there was someone in the Lethbridge area paid the neighbor $500 an acre foot for their water entitlement in July. Why? Because they had a high value crop which was about to wither in the ground. And the neighbor said, fine, I've got a low value crop, I'm way better off with $500 per acre foot, you take my water and use it, and they did. So the only controversial one, truly controversial one, was the one that Kim Sturgis talked about this morning, the transfer from the Western irrigation to Rocky View for the purpose of the Cross Iron Mills Mall. Controversial, yes, but controversial from a land use perspective. The water side of it, I submit, was not controversial. Because when we looked at what happened to that, all that we did was to take water that was otherwise lost to evaporation or seepage and put it in a pipeline instead of a ditch, and said the amount of water you save by putting in the pipeline is enough to keep the Cross Iron Mills Mall and tourist track working. So, as I say, what happened in the system was actually that the water transfer became the battleground for all reasons that people might be upset with the proposed development. I'm sorry, so we had lots of safeguards, and the most important thing about the Act is it does, again thinking about the Western Irrigation District transfer, it does contain a provision which says upon transfer, the director may, and routinely does, retain 10% of the amount being transferred as holdback, which must be left in the river. So in fact, I would say the Cross Iron Mills transfer from Western Irrigation was a win-win-win. Western Irrigation District got its pipeline, Cross Iron Mills got its water, and 10% of the amount transferred stayed in the river at Strathmore, instead of being abstracted as it had been before. So a little bit of water is reallocated for the purposes of of increasing in-stream flow. Only a little bit, I must confess. The transfer system has been in existence, as I say, 10 years. I think we've got to say that it may be unduly restrictive, not from the point of view of ensuring there are no bad environmental effects and no effect on other water users, but we have a problem where it shouldn't take 2 to 3 years to get an uncontroversial water transfer through, and it does because of the enormous procedural safeguards we've erected. We need to have better and clearer license records. We probably need to have an easy registry system, which should look something like the Land Titles Office, so you can find out what people have. We've got to improve people's knowledge of the market, and possibly have a market facilitator for a few years, only because other people have stepped into that role without necessarily knowing what they're doing. So it can be a little bit problematic in that respect. So that's my thumbnail of water and agriculture. Obviously, the subject of water allocation applies equally to the energy industry, and I'm going to spend a couple of minutes on this. The energy, must be going the wrong way, yes. What's happening in water and the energy industry? I think we're seeing 3 or 4 interesting developments there. The first is the minimum in-stream flow plan for the Athabasca River. It is only a planning document, it's not binding in law, but this says roughly that you can only remove 15% of the natural flow from the Athabasca River during the course of the year, less during the shoulder season, and hardly any at all in midwinter when the flow levels are really low. That is not law yet, but it's curiously more effective than if it was law, because it says all administrators must follow this plan in making all administrative decisions. The only way it could become law was to have that plan go to Cabinet, and I don't think Cabinet would vote for it. I think Cabinet might regard it as too restrictive. But the fact is, it is binding because administrators have been told they must apply it. It's curiously, oddly more binding than if it were in the law. And I think that the department's quite, I'm sure other people might contradict me, quite happy with that situation. I think the groundwater has been covered by our Act since 1961. You cannot take groundwater without a license. There is an exception for saline groundwater. We define saline groundwater as water of more than 4,000 parts per million salts. So a lot of water for SAG-D is taken out under this exemption without a license. There's a proposal to say you can only take water, you should only be able to take water without a license if it's more than 10,000 parts per million, which means it has to be very, very salty before you can take it out without a license. So that's an energy industry issue at the moment. And the other thing which was referred to this morning in the last presentation this morning, at the moment there are some procedural safeguards against excessive use of fresh water for hydrofracking, i.e. you've got to show that there are no other economically feasible means of obtaining water for fracking. That's leading to too many oil companies actually just going to local municipalities and buying fresh water from them instead of getting a license. I'm not sure municipalities have that power, but that's what's happening. But I can see it's not far in the distance where if there's not a prohibition against using fresh water for fracking, there's going to be something which creates a very strong presumption against it, because I don't think anyone prepared to see. The only way you can take water not exactly out of the hydrological system forever is to put it in deep wells where it's from which it's very unlikely to emerge, and it seems rather foolish to do that excessively with fresh water. So I think that's a bit on the horizon.
Okay, we have 4 minutes worth of questions, and David has kindly indicated that he'd be around tonight as well, because there's no doubt going to be a lot more than 4 minutes worth. So, anybody got a question for David? Yes, the back there.
For your fracking purposes, correct me if I'm wrong, I think it's 5,000 cubic meters of water per license that the companies are allowed to remove.
I'm not aware of a regulation to that effect. There may be a practice to that effect.
Might be just a practice, but is that what's being looked at with developing change to the laws, that they need to be restricted a little bit more and maybe have a long-term license where they are restricted for use?
Yes. Well, you know, on this part, the legal change isn't a difficult issue. It's a policy change. So it'd be very easy to implement that. You could actually say you can't use more than a certain amount of fresh water, or you can't use fresh water at all unless you satisfy certain stringent tests. But that is certainly, I would say the public concern over hydrofracking is less in this province than it is in northeastern British Columbia. It's less in places which have not used hydrofracking before, but it is there. And there's more than a nugget of common sense behind it. You should be reluctant to take fresh water out of the hydrological cycle. So will it happen? Well, this province's politics are in a blender today, and we'll find out what comes out of the blender at the other end.
Another question right there.
Just regarding the potential restrictions on the use of saline groundwater, can you elaborate? Is there anything little that you can tell us about that?
I think it's a bit bizarre. It was a recommendation of the Rosenberg Forum, a very credible international organization. And I agree that in some parts of the world, it's very important to be very careful with the use of what we would describe as moderately saline water, above 4,000, but less than 10,000. Whether that is true in a generally water plentiful region, I don't know. So I can see if you were in Saudi Arabia, you would want to control every abstraction of groundwater unless it was very, very saline. Whether that policy concern exists in northeastern Alberta, I would like to hear from some hydrologists as to whether it makes sense or not. Clearly, when a prestigious organization like Rosenberg recommends it, however, it's hard to dodge. You bring the best experts in the world to look at the problem, they say it should be 10,000. It's going to be very hard for a government in the long run to say, well, we disagree. There was another question just behind you, I think. This lady?
Yeah, I know that your name came up just before lunchtime when we were talking about putting a price to water
Yep.
market versus price.
Yes.
I'm just curious if you could add your thoughts to that.
Well, there are several ways you can reduce consumption of water. One is in the South Saskatchewan Basin, I think users are now aware there's an opportunity cost to the use of water. So that before there was no incentive to invest, for example, in more efficient irrigation systems. Why? Because why would you do it? You've got to obtain no benefit from it. If you can put a pipeline instead of your ditch, then you might be more inclined to put the pipeline in and sell the conserved water. Water is probably the only crown resource which we do not charge a fee for, and no doubt charging any small fee discourages consumption. It has been the graveyard of ministers of the environment. I don't know how many of you remember the old English series Yes Minister, But if you wanted to get a Minister of Environment fired, you would say, why don't you float the idea of charging for water? P.S. Announce it in Lethbridge. It happened to a friend of mine, a former student who was Minister of the Environment, who lasted about 6 weeks after that announcement was made. The fact is, it's obviously a public policy choice. It's very unpopular with water users, who I have to say as a group are a very effective lobby. But I mean, we charge for every other Crown resource that people use. There's no principled impediment against it. There's no legal impediment against it.
Fantastic. Thanks so much, David.